Before he starts, just to give everyone an idea of what this is about. So the DOJ has their occupational licensing review program. It's sort of a, I don't want to say competitor, but in a way, a little bit.
You know, it's kind of an insurance policy.
It's an alternative program.
That's right.
Alternative review process to the Occupational Licensing Review Commission that we currently use for our rulemaking. So currently when we're doing any rulemaking, the first step, it goes to the Legislative Fiscal Office for a financial and economic review, and then that notice of intent would go to the Occupational Licensing Review Commission for a legislative review of it and approval. This is an alternative program to the Occupational Licensing Review Commission. That comes with a little bit of extra, some extra services and some extra benefits, I guess you would say. And so, Mr. Joe here was kind enough to present, to come here and present to you guys what that DOJ's review program is.
Yep, and Jared got it exactly right. So the purpose of the OLRC, the commission, not the OLRP, the program, which is at DOJ, is to provide oversight of occupational licensing boards and the promulgation of their regulations. In 2021, the legislative session, the legislature passed some new legislation creating this program. It was requested by some specific boards in order to provide some additional oversight to both promulgation of rules and potential disciplinary actions. And in the language of the statute, it says, by establishing this program, the state intends to ensure that participating boards and board members will avoid liability under federal antitrust law. And I'll get into a little bit of the development of that law and why this program became necessary, or was at least viewed by some boards as being necessary. And the purpose of the program is for the Attorney General to provide active supervision of proposed occupational regulations and proposed anti-competitive disciplinary actions of an occupational licensing board. And if you participate in the DOJ's program, the OLRP, there is no obligation to follow the procedures that Jared was talking about, going through the OLRC, presenting the rules, coming back, and then having them adopt them after you've received comment and put it up for public notice. So the purpose of the program is to provide board members with what's called state action immunity. The Supreme Court of the United States created, it's not statutory, it's not in statute either federal or state, but in case law they developed this as a method of immunizing states and state actors from antitrust liability that when the individuals regulate occupations or professions in a manner that may affect competition. And if the state has delegated its regulatory authority to a board of quote-unquote active market participants, that is the potential, where the potential for antitrust liability lies. And state action immunity is available if the challenged action, the proposed rule, or the disciplinary action is undertaken pursuant to a clearly articulated state policy, typically statutory language, and the policy's implementation is actively supervised by a state official that is not an active market participant. So that's the little segment that this program fills, is the active supervision prong. So I mentioned the Supreme Court case law. In 2015, the Supreme Court decided the case Federal Trade Commission versus North Carolina Dental. And what the North Carolina Dental Board had done is they started taking action against these teeth whitening kiosks that were in malls and all around strip malls. They sent cease and desist letters saying you're engaging in the practice of dentistry, you have to cease doing this or we're going to sue you or bring enforcement actions against you. And up until that point, it was commonly thought, and there was law in Louisiana from the Fifth Circuit, that second prong, the active supervision, did not need to be satisfied for occupational licensing board members. And what the Supreme Court said in 2015 is, yes, occupational licensing board members or boards that are composed of active market participants do have to provide that second layer of protection, because there is the opportunity for any competitive conduct that would basically benefit a board member at the expense of other practitioners. And what the Supreme Court said is that a state board on which a controlling number of decision makers are active market participants in the occupation the board regulates must satisfy the active supervision requirement in order to invoke state action antitrust immunity.
Can I ask a question?
Sure, absolutely.
Can you speak English? Sorry, I mean, it's just, I understand what I'm trying to follow all the legalese. So can you go back to that slide and do like real world example? And I don't mean to say, can you speak English in a sarcastic manner?
No, that's fine. I'm sarcastic
It's
too.
like if I would start talking to you in veterinary.
No, that's fine.
So,
Well, and I do have to say, you know, whenever I was in private practice, I did.
so I want to understand what you're saying. So that last thing that was just up there. can you
That
go
was
back?
just about the Supreme Court case. That
Right,
was
so,
the, yeah.
But when you're saying, so in terms that a non-lawyer would understand, what did the Supreme Court say?
So again, basically what they said, prior to the North Carolina dental decision, it was the commonly held belief that if you have an occupational licensing board, the legislature,
Okay, so if we, like us.
that's correct.
Okay.
The legislature has given you authority to promulgate rules,
Right,
to
okay.
discipline, impose discipline on individuals.
Okay.
And, prior to FTC versus North Carolina Dental, the belief was that, okay, you have the statute, the board is exercising legislatively delegated authority,
Right.
and therefore they are state actors. They are immune from liability for antitrust for any competitive activity under federal laws.
So they can't, so North Carolina Dental, they couldn't come in, those teeth whitening people couldn't come in and sue the board members because they were working under their board supervision. Okay,
That would
so
be
that's-
correct.
It's an exemption to the antitrust laws if you do state action.
Define trust, because the trust is used in the legal terms as so many different things.
Anti-competitive.
Okay.
It's antitrust, because you're right. Trust can mean a lot of different
Right.
stuff, but
Okay.
the language of it, and it's a federal law, it's a federal statute. And the language that they use is legalese. It refers to cartels and things of that nature, but that's exactly right. It is any competitive conduct. So if you as a board member, if there's three vets in a small town in Louisiana, two of the vets sit on the board, and they decide to discipline that third vet, then potentially, if they don't have good justification for making that decision, then it could be considered an anti-competitive activity. You're trying to put this third vet out of business in order to bring more business to yourself. And that could potentially create antitrust liability.
Thank you, that's,
Sure.
thank you.
And I'm going to get into some more of the specific details too. This is, the AG's office obviously is concerned about the legal effects. Again, this is federal law. It's old federal law too. It's Title 15 of the United States Code goes back to the founding of the nation, and it hasn't been changed a whole lot since that time. So it does get somewhat into the weeds. But some important points about the active supervision that the DOJ program provides is that it's insufficient that there's just merely a potential for supervision. So in addition to currently going to the commission, like Jared was mentioning, you submit it also to legislative oversight committees. And the fact that those oversight committees can take action to prevent the rule from moving forward isn't sufficient for legal purposes to provide that level of immunity. The state supervisor, this was kind of touched on, cannot be an active participant. So if I was a vet, I could not supervise the actions of the board. I could not supervise actions taken by, for instance, the Committee for the Unauthorized Practice of Law because I'm a lawyer. You can't have, for the same reasons that you need the oversight if you're an active market participant, the state supervisor cannot also be an active participant because they have their own personal vested interests that may conflict with the actions that are being taken. So the active state supervisor can't just see if the boxes were checked. The purpose of the program isn't to say, okay, you have provided your public notice, you waited the proper amount of time. It's not checking for compliance with the Administrative Procedure Act. It is, does this have an anti-competitive effect? Is this something that could potentially create liability? And if so, that may be okay, but does that follow a clearly articulated state principle like I said, that typically appears in the language of the statutes that the legislature has passed that govern the board's actions. So it's a substantive review. It's not just a procedural review of the board's actions. The active supervision must precede the implementation of the regulatory action. So whether it's a disciplinary action or promulgation of the rule, the review has to occur before either the rule is put into use or the disciplinary action is actually imposed on the licensee. And the supervisor must have the power to veto or modify individual decisions. And so this is really the only thing that I think may be a point of concern for some boards, because you are giving up a certain level of authority with respect to your rule promulgation and your disciplinary process, because you do have to cede over to the Attorney General the ability to say, no, this action does not comport with the law, and therefore you either need to modify it or you need to not move forward with it at all.
So our state supervisor, the Attorney General.
That's correct. I mean, in practice, it would be me that's actually reviewing it. I'm the one that runs the program. I was brought on board to basically stand it up. But I'll tell you, it is a collaborative process. It's not as if I get an email from Jared and I don't speak to him, until that decision is rendered. There is back and forth that goes on during the process of submitting any action of the board for review, and if there's any questions or further information needs to be developed.
And currently, that is what's being done with the OLRC review. And it actually happens twice. It happens at the beginning of the rulemaking process, similar for our NAVLE rulemaking. It happened at the beginning of the process. We went through, made some additional changes to it, and then it goes to a final review to allow for a final promulgation of the rule.
So every rule that is made by any board has to be reviewed in this way,
Like
right?
it used to be just only the OLRC, and now the DOJ is, this program is an alternative.
So
An option.
if every one had to be reviewed and go through that whole process, why do we need this?
Well, so OLRC, if that's what you're relying on, yes, any rule that you promulgate will have to go through them. In the OLRP, the DOJ program, it's voluntary. So any rule that you believe may have any competitive effect, any disciplinary action that you believe may result in litigation, or someone is going to raise a fuss, those are always going to be sent to the Occupational Licensing Review Program to provide that extra layer of coverage. If you are not concerned, if you're promulgating a rule that's basically, for instance, for the medical board, or the pharmacy board, if you're updating to a new, pharmacopoeia or a new standard that's referenced in your rules, that's not something that's going to create any antitrust potential liability. And there's no need to submit that and go through the process of having it reviewed. You would still have to do that with the OLRC in both of the, both before it's at the very beginning, before it goes to public meeting or anything like that, and then again once the public meeting has been conducted and the final version of the rule is there. With the OLRP, you don't ever have to go, and you actually can't go to the OLRC. So you can move straight. It's one review with the Occupational Licensing Review Program after the public hearing, after you've got your final version, before it goes to the final oversight committee before implementation. And so again, you do have the discretion with the OLRP to just simply move to the next step without having any review or oversight from either the OLRC or the OLRP. And the boards that have participated, we're just nearing the end of our first year. That's what they've done. I mean, they've exercised that discretion. And it does speed up the process of rule promulgation by eliminating that extra step, which is 2 steps at the OLRC and 1 with our program.
It'll help, for instance, whenever I can get the chance to sit and look at the practice act and just clean up some of the language where it's not changing any of the intent. It might be a spelling.
Clarification.
It might be grammatical. It might be just taking 4 sentences where it should be 1.
Practice Act, not Practice Act, rules.
Rules. Did I say practice act?
Yes, you did.
I'm sorry.
That's all right.
Rules.
That's okay. I have a question.
Sure.
So both the commission and the program review occupational regulations for a least onerous imposition of burden on, so how is that
That's right.
review different?
The review is the same, actually.
Okay, so why is it that the commission considers that disciplinary action, it does not apply to disciplinary action, but the program does?
So that is by choice of the legislature. The legislature has stated that OLRC only reviews regulatory action, so only proposed rules. The statute that created this program says proposed promulgated rules and disciplinary actions.
How active is the program with respect to disciplinary matters?
I will tell you that I got 0 disciplinary matters. And I'll get into this a little bit too, but things such as consent agreements, disciplinary matters, ministerial actions, somebody didn't pay their annual dues or stuff like that, those things don't get sent to us either, which is and the same with substance abuse issues. Those are the majority of disciplinary actions any occupational board takes.
So we would have to be aware, in order, if we participate in the program, we would have to consider a formal disciplinary action being really potentially anti-competitive for it to be even relevant.
So, I mean, yes. I mean, if that's the tack you want to take, again, you can send it to the program without doing your own analysis beforehand. That analysis will be conducted and you will have your immunity. But, if there's something that's urgent or something or anything that you feel needs to be taken care of immediately, yes, again, you have the option not to put that through the pipeline for review.
Okay, so the immunity you're talking about applies to North Carolina dental damages.
Yes, federal trust, antitrust liability.
Okay.
Yep,
That's
you're right. I understand.
And also the declaratory judgment provisions after review of a rule?
So no, the APA provisions, which is what I believe that you're referring to, the Administrative Procedure Act, those apply regardless of your participation in either the OLRC or the OLRP. It is only the federal antitrust liability that the state immunity action applies to.
Thank you.
Yep. Yep.
I'm sorry to interrupt you.
Oh, not at all. Please, I welcome the comments. That's where most of the good information gets conveyed. So the FTC, which is the one that the federal agency that enforces the antitrust laws, they've issued guidance in the wake of North Carolina Dental on how states can implement a program to provide active state supervision, which will satisfy all of the different criteria that the Supreme Court has laid out. And the things that the DOJ's program is basically modeled on the FTC's guidance. And basically what they said is that the state supervisor obtains all of the information that the board has based its decision on that either justifies promulgation of the rule or imposition of discipline. And the supervisor evaluates all of the information that the board relied on in making its decision. And then the supervisor issues a written decision, substantive decision, discussing the provisions of the rule, its implications, and whether or not it would potentially violate antitrust law. So here's that language that I was referring to about federal antitrust law. It prohibits cartels, price fixing, and basically other practices that restrain trade or otherwise undermine the free market. It's anti-competition. Some particular details about this law is that suits must be brought in federal courts, federal law. It does create potential liability for individual board members, not the board itself, because it has 11th Amendment immunity. It can't be sued in federal court. But the individual board members can be sued in their individual capacity. It does it, sure.
So if our board goes with this program,
Yep.
after y'all review something that we're planning on doing, then there's legal action that comes against us afterwards.
Sure.
We are
I mean, that's an immediate motion to dismiss, is what it is. Yep, that's, so it can't prevent you from getting sued. You know,
Yes.
anybody can go to court and sue, no matter how frivolous or how baseless the action. But what this does is it gives a clear out for the liability of the individual board members. If you have a letter from the DOJ saying, I've reviewed your rule and this is the analysis as I see it, whether that analysis is right or wrong does not matter. It's the fact that you submitted it to the program and you received a decision and you were given the go-ahead to move forward whatever action you were going to take. That's all that it takes in order to get that immunity.
So I have a question.
Sure.
Let's say there's a law that has already been on the books for many, many, many years, and you just don't change it.
So statutes, you know, that is clearly articulated policy. Language of a statute will not create liability, but if you're referring to a regulation, then what you would do in that circumstance is you could either amend it, like Jared was saying, like you're doing, you know, just technical revisions, you could submit it at that time, or you could just submit the existing rule for review too.
Well, I'm just saying, like, if there was a rule and you consider changing it, and then it wasn't working the way you originally wanted it
Sure.
to work, why not just leave it alone? Would you still be, if the rule's already in place, do you have to, could somebody come back if the rules are already in place? Or it's there and they can't change? I mean,
If it has not gone through the review, then the protection is not there. So currently you have existing rules.
Right.
If you join the program for next year, the existing rules, you could still, you know, be sued if you are enforcing those rules or disciplining someone over them. In order to get the immunity, the rule has to be submitted through the review process.
even if the rule's been on the books for years and years and years?
That's correct. Now, you know, if the rule's been on there that long and you haven't identified any potential issue with it, then the chances of that coming back and creating new liability, it's there, but it's more than likely greatly reduced just from the fact that it's been on the books for so long. You know, there is a doctrine under the law that, you know, consistent interpretation of a rule by the entities that are charged with enforcing it is given deference. So you're not in a bad position if you're relying upon, you know, a long-standing rule, but there is still the potential for that antitrust liability or for someone to come and challenge the rule and say that it needs to be repealed. But that's always going to be there with any rule that has not gone through the process. And the repeal of the rule is always going to be there whether or not you participate in the process.
So that kind of dovetails into my question of when it comes time for sunset reviews.
Sure.
That obviously, you know, can still follow if the board does decide to go with this review program. It still follows that same, like the larger sunset reviews
Yep.
still are, I guess, a little bit more painful because you are taking a complete review of the
Sure.
rules.
Sure.
But it would still follow in that same.
That is correct. Those you know, those are parts of the APA. And the APA governs that. You know, I know for a fact that state agencies struggle with that, and most of them do not comply with it. So I understand as a board the onus that places on you to go and reevaluate the rules at different periods. But this does not provide any exemption from the provisions of the APA. So the federal antitrust law does provide plaintiffs with an avenue for treble damages, which is 3 times whatever damage has been out there. So that is, you know, one of the things that plaintiffs' attorneys will use to their benefit in federal court to bring these actions. And ORM, the Office of Risk Management in the state, they may fund a legal defense for an antitrust action that's brought in federal court, but typically they will not fund any award of damages, and they're likely legally prevented from funding any award of treble damages because there's a preclusion against punitive damages, which is typically how treble damages are interpreted. So this kind of just gives you an outline of the nuts and bolts of how the program works, how the submission of a proposed occupational regulation goes. So if for individuals that are familiar with the APA process, prior to submitting the final notice of rulemaking. So this is after the public hearing and any amendments have been made. The proposed regulations are submitted to DOJ for review by me. And there are some other subsequent reviews that go on after the initial draft of the decision occur. And basically I get a package with everything that was considered in making in taking the board's action, and then an additional form that is a DOJ form that asks for some additional information. I get that package, assign a file number, send confirmation that it's been received, and that starts the clock ticking. You know, under the contract that I've provided Jared a copy of, there's 45 days basically between the time that it's submitted and the time that the decision letter is issued.
To give an example of a difference, the OLRC, for the past 3 or 4 meetings, it's been every other month. And so you guys voted in the February meeting to repeal the requirement for letters of recommendation. That was sent the next week to the Legislative Fiscal Office for the economic review and received their approval packet. That was February 3 weeks ago, and I'm still having to wait another month before I can file to get with the OLRC to actually start the rulemaking review. So it would significantly reduce time that the reviews happen.
What's the biggest difference between the two programs? Is there a difference?
So I will tell you that the reason that the program was requested by certain boards was because, you know, I talked about that there must be a substantive review in order to get that state action immunity. And there were concerns about the level of review. And Jared can tell you, because I've seen him at the OLRC meetings. You know, that board is not funded. The folks that are on there are all appointees that don't get paid anything to be there at the meetings. And you know, there's not a whole lot of discussion typically that goes on regarding the substance of the rules. It's almost pro forma that, you know, the individual who is representing the board will get up there and give a brief explanation of what it is, and they will take a vote, and then that's basically the review that is done. So there were concerns by some boards that are more frequently targeted by plaintiffs' attorneys that they were not going to get antitrust immunity from participating in the OLRC, from just doing meeting the existing requirements. They wanted an option, an alternative that would provide something that would definitively establish that they're entitled to that immunity under federal antitrust law. Yep. So after all of the material is received, after the initial review is completed, there may be questions about some information that wasn't included. You know, why wasn't, why didn't you, what is the basis upon which you're promulgating this rule? So the state supervisor can request additional information if there appears to be something that's missing from the materials that are submitted by the board. And then once the review is completed, you do get official letter on DOJ letterhead, basically explaining providing the result and explaining the reasoning that went into it and why this is acceptable for the board to proceed with. Proposed disciplinary actions are much the same, with the exception that while the proposed regulations can be submitted over email, basically, the disciplinary actions we only want in hard copy, so that once the review is complete and the letter is issued, we can give everything back to you that was given to us, and we're not in possession of any documents that may, ultimately be tried to sought from an attorney in litigation or whatever. We don't want to have any of your confidential public records that someone can come and try to get from us. Yep.
I know this may be a hard answer to give, but what would be your typical turnaround time from the time you receive something along these lines, your office receives them?
Yep.
When should we expect a response as a rule?
So, before the program started, my goal was to do a turnaround in 30 days. being that it was just getting started, there's a lot of stuff that you've got to create the wheel for. So it was the 45 days. Next year I think will be smoother, but still, depending upon the volume of stuff that comes through too. So, if we've got a whole bunch of boards that are submitting a whole lot of stuff at the same time, that could potentially, take longer to do. And given the substance of the rule, it depends on a lot of it too. So, a lot of the times, just in the experience of the last year, the board's not just going to typically be amending one rule whenever it's going back and going through the process. There's going to be several of them. And depending on the length and the complexity of the rules, it's going to determine how long it takes to actually do that substantive review. But the contract does require that that decision letter be issued within 45 days. I can tell you that there was one instance in which I had to go back to a board over the last year and say, I needed some additional information, and actually it wasn't anything other than the form that, the DOJ form that asked for this other information that should have been submitted up front, but it took them another 2 weeks or so to provide that, and so it did extend beyond the 45-day window, but it was within 45 days of getting the complete package, basically.
And I think where the shortage, where the reduction of that processing time helps is that it's one final review. It's one review towards the end of the process versus an OLRC review at the beginning with the notice of intent. We publish that notice of intent with the register. There's open time for public comment and a public hearing request, or a public hearing if the certain criteria are met for that. Then all of that goes to the oversight committees for a 30-day review. Once that comes back, then we go back to the OLRC for their final review before it's then published, before the rule is then published and promulgated with the Louisiana Register. So instead of having two reviews, one at the very beginning and one at the end, we do the notice of intent, we do the public hearings, we do the public comment. You guys make any additional changes or not that you want. It goes initially to the oversight committee for that first review. After any changes are made, it goes to their final review. Then that entire packet is what this program would review. So
it's a third review.
So it still has to go.
I thought it
It's
was
a
taking the
singular-
place of the
yes,
OLRC.
Yeah, it's a singular review. So it takes out the two OLRC.
Okay, so you just said you did both of them and then you sent it to them.
Oh, yeah, I'm sorry, the oversight committees are the two that go. So if we were to go to this program, we take out the OLRC,
Okay.
but it still does the two oversight committee reviews.
Oh, yeah, the OLRC would still review it.
No.
No.
Okay.
No.
That's what I'm saying, I thought that was what this.
I'm sorry.
The legislative oversight committees are different than the OLRC, so you always have to submit that. Those are the bookends at the front and the end. And I'm assuming that's why the OLRC provided that initial review as well, was just to mirror the legislative oversight. But I believe I've discussed with Jared, it really makes no sense to have to submit a proposed rule at the time of the notice of intent.
There are two OLRC reviews?
Yes.
Yes.
Okay. Who's doing this, is my first question. And does it cost the board anything?
So there is an annual fee for boards to participate. I am the individual that is the point man for the program that receives them and does the review. Again, there is subsequent reviews afterwards.
When I say who, I mean lawyers? Who?
Yes, yeah, like I said, it
All
is
attorneys.
me.
Okay. Just, I didn't know if there was any. Yearly. Okay, all right, thank you.
You good?
Now, one.
Sure, no, you're fine.
I'm going to ask you a question. Let's say when we begin to do a sunset review.
Yep,
Now, your office could become overwhelmed
sure.
with, we review all these things, we say this is antiquated, we want to change this, do that. So as long as you don't have a whole group of boards wanting to do sunset reviews at the same time,
That's right.
then your turnaround may be 45 days or less.
Sure.
Under the average circumstance.
That's right, that's right. And we are going to promulgate rules for the program. We've not done that yet. But I've given Jared like I said, the draft contract and the guidance that we've developed that's basically going to be a template for the rules that the DOJ promulgates for the program. But there is no provision to really accommodate for that circumstance. I always mention it whenever I'm discussing with boards. We've not been met with that situation as of yet. Whether that's just from a belief that you let sleeping dogs lie, it's not causing a problem, and so we don't need to make a problem by putting it through there. I'm not certain. But we had 5 boards that participated during this fiscal year. Board of Medical Examiners, Board of Pharmacy, Physical Therapy, Court Reporters, and I'm missing one. Dentistry. Dentistry is the other one. So it's big boards that promulgate a lot of rules that participated over the last year, with the exception of the court reporters. They're not very big. And you asked about the annual fee. I believe, if I'm correct, Jared, that I quoted, it's based upon the number of licensees you have. You don't have nearly the number of licensees that the Board of Medical Examiners has. So it's less than $10,000 for the year for the board to participate in this program. Completely voluntary. I said you're completely entitled to rely on the OLRC if that's what you choose to do. But this just gives that added level, added assurance that immunity will be available in the event of a lawsuit.
So I'm just curious, because, so you have attorneys who go back and review these laws from all these different boards in all these different professions in these
Sure.
fields. How do you make the decision of what's right and wrong, or not right and wrong, but where is the knowledge base to know what a veterinarian does, a pharmacist does? Like, how do you do that?
So it is a legal analysis, and so it comes down to the language, the statutory language. What authority has the legislature delegated to you, and is the action that you're taking within that legislatively delegated authority? So it does come down to the language that's used by the legislature and the language of your rules, basically. You know, if there's something that, and I mean, it happens all the time. If you're an attorney and you go through the code, you can clearly see where rules, in Louisiana deviate from statutory provisions, because statutes change all the time. I mean, every legislative session, you're going to have a bunch of changes in there. But it is a legal analysis. It's not typically a substantive of veterinary science or medicine that's going to be involved. And of course, there's the legal principle that legislation and rules have to be written in a way that the individuals that they apply to have to be able to understand them. And so that's typically the way it works. I mean, I don't think I mean, there are some regulations that get really deep into the weeds, but as far as occupational licensing regulations, they're typically fairly straightforward. And I do have a background. I was going to say, I don't know if I mentioned it, but I used to spend all kinds of time in the veterinary library here at the school, because they have great medical resources. I mean, much better than the main campus. And I was doing medical malpractice work and pharmaceutical liability work in particular. And I mean, I am the type of individual who likes to dive into the weeds. I mean, that's one of the things I like to understand, the things that are going on. But that is not the deep dive type of stuff that goes on with the DOJ program. I'm not going, I mean, you are experts in your field, which is why you're sitting on this board. And that is a level of deference that you are entitled to, and which you absolutely get with DOJ.
So if you do, you've been, how long has this program been going?
This will be the end of actually it was the medical examiners had an extra 6 months, because they started after the legislation became active, effective. And so it's been a little short of 18 months that the program has been up and running.
So if someone does come up against, one of these boards comes up against an antitrust lawsuit, and they end up going to federal court?
Yep.
If they go to federal court and they walk in and they say, look, we have this from this occupational license,
Occupational licensing review program.
have you had any of the judges say, no, sorry, that doesn't mean anything? I mean, does it get overturned, or is it kind of a hard and fast saying, oh, well, if they reviewed it and said it's good, then you're good?
I can tell you that none of the rules that have gone through the program have been challenged in any litigation. I can tell you that boards that have been involved in litigation that, I have been, for lack of a better word, advising or just, basically aware of and communicating with the attorneys, they've joined the board as a result of having gone through the process of being in that litigation. I know exactly what you're talking about. Judges don't always get it right. And it does come down in large instance, and I can tell you with the Court Reporters Board, they were basically being sued over the language of a statute, which, again, that is the clearly articulated state policy, and the board members should not face liability because of what the legislature said in the enacted statute, but they were unable to get that dismissed on that basis because of the lack of active supervision. And the way that the district court interpreted it, the North Carolina decision was, no, you don't have the active supervision going on, and so therefore the case gets to proceed. And so that was one of the main justifications for them joining the program, was because they had seen it firsthand that, and that they're an even smaller board. I think they paid less than $5,000 last
So
year.
you're becoming the active supervision and you're checking that box.
That's right.
That's what this is.
That's right. It's like I said, it's an insurance policy. It's basically what it is. Yep.
I have a question. So the state,
Sure.
I'm sorry, so the state policy is to, when we adopt a rule,
Yep.
okay, it's supposed to be the least restrictive on competition.
That's right. Yep.
Okay, that's part of your analysis.
That is part of the analysis. That's correct.
So when we have discussed rules before,
Mhm.
I go to these guys and I go, hey, is this rule, okay, so that's framed in terms of protecting the public. Least restrictive, but protects the public.
That's right, and in
Yeah.
accordance with the statute.
Right.
Because again, yeah.
Right.
It's not
Definitely.
just whether it's anti-competitive or not.
Right,
Yeah.
right,
sure.
but assuming it's within
Sure.
the statutory
Yep.
delegation of authority to do that. So I go to these guys as experts and I go, are we protecting the public
Yep.
if, not a legal interpretation, a matter of medicine?
Sure.
Are we protecting the public if we change the rule in this way and broaden competition?
Yep.
Where does your review take that into account?
So that, well, I mean, hopefully that analysis will appear in the materials that I get.
It's
And
our
so-
justification.
That's exactly right. Yep. Why did you do this? And yes,
Okay.
you're familiar with the practice of veterinary medicine.
I'm trying to get, where do you know what the right answer is? Because if you're not a veterinarian or you're not a court reporter, how do you know if we come up with these as our job to protect the public, if we
Yep.
come up with this rule, and that least restrictive thing, I mean, to me, that is so vague.
I don't disagree
mean,
with you. It's a difficult standard. Yeah.
least restricted by what? So
Sure.
anybody can come in and do whatever they want. That's the least restrictive. Do whatever you want, But then where does protecting the public, which is our job, come
Yeah.
into play? And so what I'm saying, that Steve answered it, is how do you go through all these different boards and know, because you're not those different people, so what it requires to meet those standards and to protect the public and to, make sure that people are doing what they're supposed to be doing.
Sure.
To ensure that the public is getting a veterinarian and not someone who is just decided today that I'm gonna take care of your animal,
And I mean, the analysis is, I just go back to, it's okay, does the statute authorize this action? Yes, it is authorized. Is there sufficient justification for the action that's being taken? And Jared will tell you, when you promulgate a rule, you've got to, fill out 3 different things of how this is going to impact different things. So is there going to be a financial result? Is it going to impose a big financial burden on the licensees? And does that burden, is that justified by the problem that's trying to be remedied? So where you get in trouble in an antitrust suit is if you make that decision and the analysis hasn't been performed. If you've done the legwork and you've considered the proper information, then that's really what's required. If you're just doing it without going through those steps, that's where the risk lies. guidelines. Or no, you're fine. I just want to say, or if, it's a little bit of a ridiculous, hypothetical, but if there's evidence that we're doing this in order to reduce competition and it doesn't, match up with your authority or for a reason that's not within the authority that's been granted, that's a clear, indication that there's problems here. Go ahead.
Okay. Excuse the nature of this question, but it's what I do.
Sure.
We're buying an insurance program for antitrust damages.
That's right.
What if the court ignores this, or do y'all hold us harmless?
No, that is not something
It's not an
that we would be
insurance
able to do.
It's not an insurance, to
but
that extent, it's not an insurance.
I could. No, you're right. Yeah, it isn't an insurance policy. It is a statutory oversight program for occupational licensing boards. It's a shortcut way of referring. The reason that it exists is
It is a layer of protection.
That's right.
And I understand that, but it's not an insurance policy.
No, it's not an insurance policy. No, our contract is, I think, 2 pages, maybe 4 pages. I forget. It's not an insurance policy.
I understand. I
It's
just
legible print, it's not like that.
That's right. I'm near the end. This is the last slide. Just some final points. And it's that reasonable restraints on competition are not a bad thing. The legislature very frequently passes legislation that imposes a restraint on trade. And that does not mean that it's unlawful or that it's wrong or anything else. That's within the legislature's authority, and that's the reason for the state action immunity doctrine, is that the state, acting as the state, can impose restraints on trade or the free market. But individual board members who are taking actions that affect people that they're in competition with presents the opportunity for improper actions to be taken, which is why the Supreme Court requires that extra level of review. Ministerial acts of the board engaged in your good faith performance of your duties don't present any potential risk of liability. So like I was saying, somebody doesn't pay their annual dues to renew their license, you're fully justified in revoking their license pursuant to the existing rules. Taking whatever action is authorized in there.
let me ask you a question. on
Sure.
that. Just say we have a blatant case of malpractice.
Yep.
How does that dovetail? I mean, how are we exposed to antitrust damages for a blatant, provable, under the APA standards,
Sure.
act of veterinary malpractice?
So again, you don't have to have a good claim or a good cause of action in order to file a suit. This again puts just another arrow in your quiver to be able to deal with that. And in the event, particularly that you expect that there is going to be legal action that results from an action that you take, there is no reason at all why you wouldn't submit that over to the program to be able to have that letter, to be able to at least assert that defense.
We will have paid for any submissions as we want.
That's right. That's right. There is no limit on the number or the amount, and I can tell you that the legislature, the way they've broken down the fee, it's based upon the number of licensees. And the small boards, I've talked about the bigger boards submitting lots of rules, but some of the small boards, they do a lot too. And so it's not necessarily the best way to apportion the cost of the program, but that's the way the legislature's done it. And certain boards get the benefit of the larger payments made by the boards with lots of licensees.
DEQ, do they participate?
So that they're not an occupational licensing review board.
Okay.
It's only for, again, the active participants that are sitting on there. As a state agency, they clearly have state action.
But with respect to rulemaking,
Yep.
could they participate if they wanted to?
No, they could not, because it is specific to occupational licensing boards. Again, as a state agency, they have that state action immunity.
Yeah.
They are not active market participants because they are the state. And so that, you know, antitrust liability, any suit that was filed in federal court against them,
That's
it's
state
11th Amendment immunity. You know, they've not waived their immunity to be sued in federal court, and so that's their argument. Again, you can't stop them from suing you,
Right.
but that's the argument that gets you out if you're DEQ or DOTD or anywhere
I
else.
only ask because of their rulemaking is so.
Oh, yeah. And I mean, you know, they have, the APA provides specific provisions for DEQ because the EPA, you know, and I worked at DEQ shortly after I graduated undergrad. I mean, it's basically a federally funded program that implements the EPA's law. So when the EPA's rules change, DEQ's rules change, and there's specific provisions in the APA to accommodate those circumstances. Yep.
Thank you.
Absolutely. So that was all I had. If there's any other questions, I'm happy to answer them. Otherwise, I've told Jared the deadline to join the program for fiscal year 2023-2024 is the end of May. And so, you know, we will need a board resolution, you know, authorizing to join the program, and then execution of the contract based upon that resolution. So, thank you for your time.
Thank you.
And that's my contact information. If anybody thinks of anything afterwards or has any questions, feel free to reach out. I'm happy to talk.
Thank you.
Well, Mr. Donahue, we just want to tell you you've been extremely informative.
Yes.
We appreciate you taking your time to come, and not just educate us, but from the dean's standpoint and all of our guests too. We
Sure.
appreciate it very much. Thank you.
Thank you. Thank y'all.
Yes, sir. Appreciate it.
Appreciate it.
If you read the statute, they can revise, they can make their own wording if they want to. They can repeal that. He says it's an interactive process, and I have no reason to dispute that. But if you look strictly at the statute, they can repeal, revise, modify, reject, whatever, and we would lose control over the language. That's the
But you
downside.
can still kill it.
I think you can withdraw it, right? Yeah, you can withdraw the change.
Just
I
the same thing.
I shook my head, but I'm only 95% sure of that. I would have to give out an ask.
We wouldn't be making a change unless it was something
But if-
needed, so.
But ultimately, at the end of the day, that's what the oversight committees can do as well. They come in and say, well, we don't like this, and
Right.
toss it out, or
But
the
but
governor.
we get to redraft
No,
it.
we get to report.
We get to
Oh, yeah.
redraft it.
I don't
though.
know.
Okay.
I don't know because the program is really new, these regulations. I have to be careful because I have personal opinions and I can't give those to you because I'm here, like in the Attorney General's. You know, I don't want to say, you know, some of that on the record, but I think if you're gonna make a lot of regulatory changes in the next year, which it sounds like you might be doing, you might as well do it. You can always withdraw from the program for 1 year.
That's the great thing about it, is that it's not a standard 3-year contract that we have to do, and that will be presented to you guys at the May meeting for all of our 5 or 6 other contracts. It's an annual.
And it's
an
only the
annual-
rules we choose to set forward to them. It's not, if we don't feel like it's a rule that they need to review, do we have to do
No,
every
you
rule?
don't. There's some, Board of Pharmacy sends some rules to them, and they're like, that has, it's not.
It's our discretion.
Yeah, it's not substantive. Yeah, we can send everything. If you're just taking out the word being, putting in, we can send everything to them.
And I think the best benefit that is very clear that you get from it is that new statute about the least, that you have to have the least
Least restrictive.
restrictive.
Yeah.
There's a special part in there where if someone sues you, someone can, anyone, any citizen, they don't have to be a licensee, can now come and challenge your regulations and say that they're not the least restrictive. And then if you don't change it, they can sue you in court.
For declaratory judgment.
And if they win in court, you have to pay their attorney's fees and costs,
Unless it's been.
unless they have reviewed that regulation. So to me, that is probably the most tangible, clearly tangible benefit that
I believe.
I see. And since that statute is new and there are some national groups going around the country trying to challenge occupational licensing boards, I don't know that they get to you
I'm just
guys.
wondering how they think people are gonna continue
Yeah.
to serve on these boards when they allow, it's like, it's the same thing with the policemen, when they said they were gonna start letting them sue the policemen.
Well, the damage she's talking about has to come from our operating.
Yeah, these aren't personal, this is from the,
This is,
Okay.
she's talking about there's.
You're about to lose a whole police force.
I-
with that
Listen,
law that they're
there,
trying to
I get
pass.
it,
but the board would have to pay, out of your budget,
right.
you'd have to pay their
But not
attorney's fees and
individual.
costs.
Not it, okay, that's
So-
my question, it's not individual, it's
No.
through the board.
There's now a
Okay.
public review of rules, a right to public review of rules. And they can file a motion petition for us to review a rule. And we have 90 days to either start the rulemaking process or deny. If we deny, they have a right of action to go to district court and ask for a declaratory judgment. At which point, it's our burden to show that this is the least restrictive means of protecting the public as it affects competition. If we can't prove that, then there's an award of attorney's fees. Unless the rule has been reviewed by the program.
Do I have a motion? Larry makes a motion.
I'll make a motion.
We approve the OMRP for our board for this next year or whatever their deal is. Do I have a second?
Second.
Seconded by Dr. Marulla. Any discussion? All in favor, say aye.
Aye.
Opposed, nay? Okay, let's move.